witnesses, any possible transaction documents with regards to the accusations that they had made, and of course any evidence that they deem important in making their accusations valid in this case before the Senate. And of course from the governor also too made their submission in this case any evidence that will be countering the accusations that have been made against it, and of course any other evidence that the particular party or the council will deem fit to enable it absolve the governor of the accusations that have been leveled against her. So once the hearing starts, then the Speaker will set the rules of the House on how the whole process will be taking place today and tomorrow. And of course, the two parties, that is the County Assembly and the Executive, will be given their time, of course, to introduce themselves and any council, if any, that is their legal team that will be helping them in presenting or making their case, and on the other hand, also countering the accusations that have been leveled against the governor. Standing Order 80 of the Senate, Part 3, indicates that the governor shall have the right to appear and be represented before the Senate or a special committee during the investigations. Remember, in this case, the House resolved to go the plenary way. So in this case, the governor will be appearing before the Senate, that is the whole House, that has 67 senators, and will be able to appear and be represented, in this case, of course, with her or the executive's legal team during the investigations. So the House is currently on a brief break. Remember, earlier on, the House sat in a closed door session. Of course, remember, once the submissions were made on Saturday, the members also had the opportunity to interact with some of the submissions. And of course, this morning, in the closed door session, they also further had an engagement with the submissions to familiarize themselves on what exactly the case entails, the accusations, and any evidence that has been presented. Of course, this is to give them that particular opportunity to be able to have a clear understanding of what will be discussed as the hearing begins. And of course, each and every member will have an opportunity to scrutinize what the County Assembly of Meru has leveled as accusations against the governor in a way that they have resolved to have her removed from office. So that is part of what this sitting will be looking at. Remember, today is day one, and tomorrow will be the culmination of the hearings. And once the hearing is done, at the end of it, of course, we will have the members vote on each of the charges. 7 charges are facing the governor, including misuse of funds, misappropriation of funds, and misuse of county resources, among other charges, but they are cumulatively 7, and in each of these accusations, then the County Assembly, which is the one that resolved to have the governor removed from office, will be required or needed to give evidence to those accusations, and at the end of it, the senators or the House will see whether the accusations can be substantiated or not. And of course, there will be a communication from that point from the Speaker. This is not the first time Governor Kawira Mwangaza is finding herself before the Senate answering to charges of misappropriation and misuse of county resources, or with regards to impeachment. This is the second time. In 2022, the month of December, the governor was at the Senate facing the first impeachment proposal that was also forwarded by the County Assembly. In this case, that particular impeachment hearing was done by a committee, an 11-member committee, which on Tuesday, members resolved that they will not be going the committee way, but they resolved to have the investigation be done at the plenary. There is the Governor, Honorable Kawira Mwangaza, already seated at the chambers. Remember, I told you that the official hearing has begun, and once the Speaker has set the rules on how the procedure will be done and the program of the hearing, then the two parties, that is the executive, Honorable Kawira Mwangaza, and the council, if any, will be given an opportunity to introduce themselves so that the honorable members will know that this is the legal team that is representing the executive, as well as the County Assembly will introduce themselves with their council, so that the honorable members will also understand that this is the legal team that is representing the County Assembly. So the Governor has already taken her seat, of course, with the legal counsel, and we will also be able to see the team that is representing the County Assembly. The legal team that will be representing the Governor. There is Council Elisha Ongoya. I think we have seen him seated just near the Governor. There is also Elias Mutuma. He's also one of those that we have just seen seated next to the Governor. It's a list of 9 councils that have been forwarded to the Senate that will be representing the Governor as the legal team. That is Elisha Ongoya and Elias Mutuma seated right next to the Governor. I believe there is another group on this other side that is seated. Once we have their pictures, then we'll be able to identify them. The County Assembly also has its representative in the legal team. If I could go through the whole list of the council that is representing the Governor, is that there is also Duncan M. Okubasu, Brida N. Kimathi, Robert Mutembei, Batista Mwirigi, Anthony Mwenda, Collins Mwenda, as well as Branley Maingi. This one is an assistant to the legal team. But of course, once the introductions are made, then we will be able to, of course, see their faces as well as confirm their presence at the chambers in making their representation for the Honorable Governor. This side of the National Assembly is also present, and they have their legal team as well that will be helping the County Assembly to prove or make valid their accusations, of course, with the help of any evidence that they have. If there are any witnesses or if there are any sworn affidavits, then this is the time that we will be seeing them presenting before the senators. Remember, the senators have already interacted with the submissions that were made by the both parties on what exactly entails of the case, what evidence there is, and what counter evidence there is from the executive, that is the Governor, that will be presented before the Senate this morning. So once the case begins or the hearing begins, then these two parties will be making public their evidence, as well as any other material that will be used by either parties to help this particular case move on. At the entrance of the chamber, As you've seen, one side is the governor seated, and on the other side is the county assembly. Of course, representatives, or should we say supporters of either parties, have also been allowed the speaker's gallery. They will be following up the hearing. In this particular case, we have been seeing this happening once a governor or a deputy governor is brought before the Senate to answer to accusations that are leading to his or her impeachment or removal from office. Then there is usually a group of supporters that come along or tag along with their leaders or with the party that they are leaning towards. And of course, we have these two parties that are already present at the speaker's gallery to follow keenly on what the particular case will be addressing and of course dealing with. So currently members are coming back into the chambers from a short break or a brief break after a closed door session with the speaker. They have been familiarizing themselves with the documents that were submitted before the office of the clerk at the Senate by Saturday. And of course, they are now aware of what is being said by both parties and will be able to scrutinize the allegations or the accusations one by one in a very keen manner. Remember, all senators will be participating in this case because the hearing is done the plenary way. The speaker, all right, members going back to their seats, allow me to hand you over as the speaker is leading this hearing. Good morning.
Senator Wafula, take your seat. We need to proceed. Now, honorable senators, Senator Karen and Senator Wafula. Honorable Shakila, you can still proceed and take your seat. Senator Mazayo and Mogeni, I will allow you this time around to walk and take your seat while I'm on my feet. Thank you. Now, honorable senators, ladies and gentlemen, having dispensed with the pre-hearing meeting of senators, which was a closed session, it is now time to commence the proceedings of the proposed removal from office by impeachment of Honorable Kawira Mwangaza, the Governor of Meru County. By a letter reference number M/Volume 4/43, dated Thursday, 26th of October 2023, the Speaker of the Meru County Assembly informed the Speaker of the Senate that at a sitting of the Meru County Assembly held on Wednesday, 25th October 2023, the Meru County Assembly approved a motion for the removal from office by impeachment of Honorable Kawira Mwangaza, the Governor of Meru County. The Speaker of the County Assembly of Meru also forwarded the following documents to the Senate, being the record of proceedings of the County Assembly and the evidence adduced in support of the impeachment motion. 1. Copy of approved notice of motion for the proposed removal from office of the governor dated 16th of October 2023. 2. Order papers for the county assembly sittings held on Tuesday 17th of October, morning sitting, and Wednesday 25th of October 2023, morning sitting. Honorable Senators, Senator Siengo and Senator Oburu, you may walk and take your seats. This communication is fairly lengthy. Number 3 is certified Hansard reports of the assembly sittings held on Tuesday, 17th of October 2023, morning sitting, and Wednesday, 25th of October 2023, morning sitting. Certified Hansard reports of the assembly sittings held on Wednesday, 18th of October 2023, afternoon sitting, and Wednesday, 14th June 2023, afternoon sitting. Copy of certified signatures of county assembly members in support of the impeachment motion for the removal of the governor of Meru County dated 25th of October 2023. Certified copy of roll call vote of Wednesday 25th of October 2023 on the motion for the impeachment of the governor of Meru County. Copies of the county assembly reports referred to during the debate on the motion for removal of the governor of Meru County. And the reports are: A, report of the Select Committee on County Budget and Appropriation of the budget estimates of the County Government of Meru for the financial year 2023-24, dated 13th June 2023. B, report of the Secretary Committee on Justice, Legal Affairs and Cohesion on the complaint by His Excellency, the Deputy Governor, Meru County, to the County Assembly against his alleged exclusion from County Executive Committee meetings and non-facilitation of his office dated 17th of October 2023, and the response to the petition number 4 of 2023 urging the County Assembly of Meru to investigate the alleged illegal employment of traffic marshals by Her Excellency the Governor of Meru County and alleged illegal traffic charges by the Meru County Enforcement Department. Copy of a letter reference DOM/1/2023 dated 24th of October 2023 by Messrs. Dunstan, Omari and Associates Advocates addressed to the Speaker of the County Assembly of Meru. Number 9, copies of newspaper advertisements appearing on the Standard and Daily Nation of Wednesday, 18th of October 2023, and copies of the invoices for radio advertisement in Mwangaza FM calling for submission or memoranda on the notice of motion for the proposed removal from office of the Governor of Meru County. 10, a HP flash disk, 2 GB, containing video annexures evidencing the particulars alleged in the motion, as well as voice advertisement on the public participation on the motion run on Meru FM and the approved notice of motion and exhibits. 11, copy of public participation report dated 25th of October 2023, laid on the table of the Assembly on Wednesday, 25th of October 2023. 12, copies of written memoranda, both in support and against the impeachment from different sub-counties and regions submitted to the County Assembly during the public participation exercise on the motion. And lastly, a booklet of the 3rd edition of the County Assembly of Meru Standing Orders. Now, Honorable Senators, pursuant to Section 333(3)(b) of the County Governments Act and Standing Order 81A of the Senate Standing Orders, at the sittings of the Senate held on Tuesday, 31st October 2023, the charges against the Governor of Meru County, as contained in the motion of impeachment by the County Assembly of Meru, were read to the assembled Senate. Honorable Senators, ladies and gentlemen, allow me to remind you of the mandate of the Senate in relation to the proposed removal by impeachment of the county governor as provided for under Article 181 of the Constitution, as read together with Section 33 of the County Governments Act 2012 and Standing Order 80 of the Senate Standing Orders, in particular Article 181 of the Constitution provides as follows. 1. A county governor may be removed from office on any of the following grounds. A. Gross violation of the Constitution or any other law. B. Where there are serious reasons for believing that the county governor has committed a crime under the national and international law. C. Abuse of office or gross misconduct. Or D. Physical or mental incapacity to perform the functions of the office of the county governor. 2. Parliament shall enact legislation providing for the procedure for removal of a county governor on any of the grounds mentioned in Clause 1. Section 33 of the County Government Act 2012, Senate Standing Order 80 and the third schedule to the Senate Standing Orders provide for the procedure to be followed in the hearing and determination of the proposed removal from office by impeachment of a governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may either, by resolution, appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Honorable Senators, we recall that at a sitting of the Senate held on Tuesday, 31st of October 2023, the motion for establishment of a special committee was defeated. This, therefore, paved the way for a default position, the hearing of the impeachment charges against the governor of Meru County to be held by the Senate sitting in plenary. Honorable Senators, ladies and gentlemen, by way of a status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of the governor in plenary, the Senate invited the governor to appear and be represented before the Senate during its investigation. The Senate further invited the governor, if she so chooses to appear before the Senate, to file an answer to the charges with the office of the clerk of the Senate by 5 p.m. on Saturday, 4th of November, 2023, setting out the following. 1. The governor's response to the particulars of allegations. 2. The mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3. The names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And lastly, any other evidence to be relied on. Pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate notified the County Assembly of the date for the commencement of the investigation and invited the County Assembly to designate members of the County Assembly who shall appear and represent and be represented before the Senate during the investigation. The County Assembly was further invited, if it so chooses to appear before the Senate, to file with the office of the clerk of the Senate by 5 p.m. on Saturday, 4th of November, 2023, setting out documentation as follows. Designating the members of the County Assembly, being not more than 3 members, if any, who shall attend and represent the Assembly in the proceedings before the Senate. 2. Indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3. Indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And lastly, specifying any other evidence to be relied on. Honorable Senators, ladies and gentlemen, on Saturday, 4th of November, 2023, the office of the clerk of the Senate received a response to the invitation to appear issued to the governor dated 4th of November 2023 from Mutuma Gishuru and Associates Advocates, who indicated that the governor had appointed the firm to represent her in the proceedings before the Senate and that the governor would also appear in person and by advocates. The letter also indicated the list of counsel representing the governor and the list of witnesses for the governor. Similarly, on the same day, the office of the clerk of the Senate received a response to the invitation to appear issued to the County Assembly from Messrs. Muthomi and Karanja Advocates, reference number T006/003/L 2023M, dated 4th of November 2023, indicating that the firm had been appointed to represent the County Assembly. The letter also indicated the list of advocates to represent the County Assembly and a list of witnesses for the County Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal of a governor and plenary, the Clerk of the Senate furnished each party with a documentation filed by other party in accordance with Rule 6 and 7 of the Rules of Procedure. Senator Eddie and Senator Hamida, you may walk in and take your seat. Honorable Senators, ladies and gentlemen, the hearing program which has been circulated details the various activities in the hearing and determination of the matter and the time allocated to each activity. It will be crucial that all the parties comply with the time allocated. The parties will be notified of the balance of time on each activity through the clerks at the table. In summary, the program states that today, Tuesday, 7th of November 2023, after we have dispensed with preliminary matters, the charges against the governor, as submitted by the County Assembly, shall be read to the governor. This will be followed by an opening statement by the County Assembly. Thereafter, an opening statement shall be made by the governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence and should take us up to the end of today's sitting. At the sitting scheduled for tomorrow, Wednesday, 8th of November 2023, the governor will have an opportunity to present her case before the Senate. This will be followed by closing statements by each of the parties for a period not exceeding half an hour each. The Senate shall then proceed to a debate prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate this debate. In accordance with Section 33(7) of the County Governments Act 2012 and Standing Order 86 of the Senate Standing Orders, the voting shall be by county delegations. The governor shall cease to hold office if a majority of all county delegations of the Senate vote to uphold any impeachment charge. If, however, the vote in the Senate fails to result in the removal of the governor, pursuant to Standing Order 87, the Speaker of the Senate shall notify the Speaker of the Meru County Assembly accordingly. Now, honorable senators, ladies and gentlemen, I now invite counsel for the Meru County Assembly to introduce the legal team of the County Assembly and the members of the Meru County Assembly representing the County Assembly by stating the full name and designation of each person. Kindly proceed.
Thank you very much, Mr. Speaker and honorable senators. My name is Mudhomi Vienkolu, an advocate and lead counsel for the County Assembly of Meru. I am assisted by Mr. Muvege Jacob Bwele, an advocate, Mr. Maranya Domiciano Mari, an advocate, Mr. Ngure Benson Kinyua, advocate, Kawira Boniface Mwereru, advocate, Faith Mutua, advocate, Muirigi Eric Murioki, advocate, Wanyenji Dennis Jeroge, advocate, and Mr. Kenson Mutethia, legal assistant. The witnesses that the Assembly proposes to call are Paul Mwaki Aremi, Dr. Gitonga Jeremiah Luruti, Honorable Kawira Evans Karia, MCA, Honorable Mugambi Redikiri Muruidhania, Member of the National Assembly for Bori constituency, Mr. Muroki Patrick Nkunga, who was the PA to the Deputy Governor. We propose to call Mr. Kaumbudu Paul Gikamati, and when we get there, Mr. Speaker, if we get your leave, any other witness that we may deem relevant, subject of course to your direction. We have brought the following MCAs as per your clerk's directions. The Honorable Dennis Kiogora, DMK, who is an MCA of the Meru County Assembly. Honorable Kiramana Aurelio Murangiri, who is an MCA, and Honorable Zipora Gaki Manyara, who is an MCA. We have 3 members of staff also present. Teresa Chokera, who is Senior Sergeant at Arms at the Meru County Assembly. Lidsi McKenna, who is the Deputy Director of Research at the Meru County Assembly. And Mr. Edward Murethi, who is the Chief Sergeant at Arms at the Meru County Assembly. That's the team from the County Assembly, Mr. Speaker.
Thank you. I now similarly invite Counsel for the Governor to introduce the legal team representing the Governor and the Governor by stating the full name and the nation of each person.
Thank you so much, Honorable Speaker. My name is Elisha Ongoya, counsel leading the team of the Governor. Other counsel appearing alongside me in this matter are Mr. Elias Mutuma, counsel, Dr. Duncan Munabi Okubasu, learned counsel, Mr. Robert Mutembei, learned counsel, Ms. Brida Kimathi, learned counsel, Mr. Batista Muirigi, learned counsel, Mr. Anthony Mwenda, learned counsel, and Mr. Collins Mwenda, learned counsel. We are also supported by Mr. Branley Maingi, a legal assistant. The Governor, Her Excellency Honorable Kawira Mwangaza, is also present. In terms of the witnesses that the Governor's team shall call in this matter would be Her Excellency Honorable Kawira Mwangaza herself, Honorable Nicholas Kinyua Josephat, Mr. Arayaru Adrian, and Mr. Dixon Munene. And that is the list, Honorable Speaker.
Senator Faki, take your seat. On behalf of the Senate, I welcome the County Assembly's team, the Governor's team, members of the public and the media, to the Senate and to these proceedings today. I now invite the clerk to read the charges against the Honorable Kawira Mwangaza, the Governor of Meru County.
Order number 2, reading of the charges on the proposed removal from office by impeachment of Honorable Kawira Mwangaza, Governor of Meru County.
The Honorable Kawira Mwangaza, Governor of Meru County, please take the stand. Honorable Kawira Mwangaza, the Governor of Meru County, the charges against you as received from the County Assembly of Meru are as follows, and I quote, Charge 1, misappropriation and misuse of county resources. The Governor has grossly violated, among others, Articles 10, 73, 201, 226, Clause 5, 227 and 232 of the Constitution, Sections 8, 12, 13, 1, 16, 17, and 35 of the Leadership and Integrity Act 2012, that is the Integrity Act, Sections 55 and 66 of the Public Procurement and Asset Disposal Act 2015, that is the Procurement Act, and Sections 45, subsection 2, and 46 of the Anti-Corruption and Economic Crimes Act, that is the Anti-Corruption Act, by engagement, connivance, and or complicity in the following. A, the embezzlement of county funds through the governor's sisters, that is Rose Kinya Gwantai and Miriam Gwantai, brother, that is Kenneth Gwantai Murangiri, brother-in-law, that is Nefat Kinywa, and the nephew to the governor's husband, that is Edwin Mutuma Murangiri, all of whom are from now on collectively referred to as the governor's relatives. B, the withdrawal of county funds under the guise of payment for various supplies by the governor's relatives, yet they, that is the governor's relatives, are ineligible to tender for or supply any goods or services to the county government. C, paying full salary and benefits for more than a year to Dr. Ntoiti, that is CEO of County Revenue Board, Paul Mwaki, that is CEO of Liquor Board, Peter Kimathi Mbae, CEO of Meru Microfinance, and Joseph Kithure Mberia, CEO of MEWASS, while knowing that those officers were not rendering any services to the county. And D, the diversion and misuse of county resources, including funds and motor vehicles, to run the governor's private charity, dubbed Okolea, despite a previous promise to the Senate in the previous impeachment proceedings to refrain from conflating official county operations and Okolea operations. Charge number 2, nepotism and related unethical practices. The particulars of this charge are as follows. The governor has grossly violated, among others, 1, Articles 10, 232, 235, and 236 of the Constitution, 2, Sections 12, 17, and 24 of the Public Officer Ethics Act 2003, 3, Sections 13(1)(b), F, 13(1)(b) and F, Section 16 and 24 of the Leadership and Integrity Act 2012, and 4, Sections 55, 59, 59A, 60, 62, 63, 64, and 65 of the County Governments Act 2012, that is the County Governments Act, by engagement, connivance, and or complicity in the following. A, fraudulently misrepresenting the governor's relatives as a technical team for purposes of travel to China to inspect and certify cancer treatment equipment while knowing that the governor's relatives are not medical professionals. B, employing Edwin Mutuma Murangiri, who is a nephew to the governor's husband, as the CEO of Meru Youth Service, MYS, and the acting chief officer of the Department of Finance. C, the designation of Nefat Kinywa, who is the governor's brother-in-law, as the director of external linkages without transparent and competitive recruitment. And D, assigning diplomatic duties, namely engagements with foreign diplomats and dignitaries, to her unqualified sisters, namely Miriam Gwantai, PA, and Rose Gwantai, bodyguard. Charge number 3, bullying, vilification, and demeaning other leaders. The particulars of this charge are as follows. The governor has grossly violated, among others, 1, Articles 10, 19, 2, 28, 73, 75, and 179 of the Constitution, 2, Sections 9B, 19, and 24 of the Public Officer Ethics Act, 3, Sections 29 and 34 of the Leadership and Integrity Act, and 4, Sections 30, subsection 2 and 3C and D of the County Governments Act by engagement, connivance, and or complicity in, among others, the following. A, exclusion of the Deputy Governor from County Executive Committee meetings and other official functions. B, bullying, undermining, and posting insulting and demeaning messages about the Deputy Governor in a WhatsApp group styled Third Government 012, whose membership includes several officers who are subordinate to the Deputy Governor. C, encouraging and condoning insubordination and the making of insulting and demeaning public utterances by subordinate staff against the Deputy Governor and other elected leaders. D, bullying, undermining, and posting insulting and demeaning messages about the Deputy Governor in a WhatsApp group styled County Admin Services, whose membership includes several officers who are subordinate to the Deputy Governor. E, encouraging and condoning the removal of the Deputy Governor by junior officers from official county WhatsApp communication forums. F, arbitrary suspension, dismissal, withdrawal, and frustration of the staff of the Deputy Governor. G, illegally, irregularly, and fraudulently hounding the Deputy Governor's staff out of office by purporting to accept their non-existent resignations. H, arbitrary reduction, suspension, and withdrawal of budgetary facilitation for legitimate operations of the office of the Deputy Governor. I, threatening to inflict bodily harm against the Deputy Governor orally and in WhatsApp chats. J, forceful breaking, entry, and ransacking of the Deputy Governor's office. K, changing the locks of the Deputy Governor's office. L, arbitrary relocation of the Deputy Governor's office. M, arbitrary withdrawal of security from the Deputy Governor's residences. N, persistently making demeaning public utterances against other elected leaders despite the same issue featuring prominently in previous impeachment proceedings. O, making insightful, insulting, and demeaning remarks against other leaders by falsely accusing them of cartelism at a presidential Thanksgiving service held in Lare, despite this issue arising in previous impeachment proceedings. And P, encouraging, conniving, and condoning her husband's insulting and demeaning public utterances and musical performances against other elected leaders, despite this issue featuring in previous impeachment proceedings. Charge number 4, illegal appointments and usurpation of statutory powers. The particulars of this charge are as follows. The governor has grossly violated, among others, 1, Articles 10, 41, 201, 232, 235, and 236 of the Constitution. 2, Section 17 of the Public Officer Ethics Act. 3, Sections 45, 55, 59, 59A, 60, 62, 63, 64, and 65 of the County Governments Act. 4, Section 4 of the Public Appointments (County Assemblies Approval Act 2017. 5, Section 34, Subsection 3 of the Public Service Commission Act 2017. 6, Section 9, Subsection 2 of the Meru County Revenue Board Act 2014. 7, Section 4, Subsection 2 of the Meru County Alcoholic Drinks Control Act 2014. 8, Section 11, Subsection 2 of the Meru County Microfinance Corporation Act 2014. And 9, Section 18, Subsection 2 of the Meru County Water and Sanitation Services Act 2014, by engagement, connivance, and or complicity in, among others, the following. A, appointing Kenneth Mwiti Riungu as a chief officer without county assembly approval. B, sending Dr. Ntoiti, CEO of County Revenue Board, Paul Mwaki, who is the CEO of Liquor Board, Kenneth Kimathi Mbae, the Managing Director of Meru Microfinance Corporation, and Joseph Kithure Mberia, the CEO of MEWAS, on indefinite compulsory leave with full salary and benefits in the usurpation of the powers of the appointing authorities under the relevant Meru County laws. C, deploying other persons in breach of a court order to perform the functions of the persons alluded to in subparagraph C above. D, appointing unqualified persons, namely Edwin Mutuma Morangiri, Kenneth Mwiti Riungu, and Gitobu Nkanata, as acting chief officers without the requisite competitive recruitment and recommendation of the County Public Service Board. E, disregarding the criteria for the establishment of offices within the County Public Service by recruiting traffic marshals without the involvement of the County Public Service Board. F, usurping the powers of the County Public Service Board by creating offices of the traffic marshals, which is the sole preserve of the County Public Service Board. G, employing a bloated workforce, more than 100 personal staff in the office of the governor. H, irregularly designating and paying various cleaners as senior support staff while having 16 support staff. And I, appointing the following persons to hold county offices in an acting capacity for more than 6 months. 1, Monica Kagwima, Chief Officer Youth. 2, Koome Muthuri, Director Health Services. 3, Francis Mungai, CEO County Revenue Board. And 4, Silas Mbaabu Muguna, CEO Liquor Board. Charge number 5, contempt of court. The particulars of this charge are as follows. The governor has grossly violated, among others, Articles 10 and 73 of the Constitution, 2, Section 7 of the Leadership and Integrity Act, and 3, Section 10 of the Public Officer Ethics Act, by connivance and or complicity in a contumacious, stubborn refusal to obey lawful court orders. 6, charge 6, this is charge number 6, illegally naming a public road after her husband. The particulars of this charge are as follows. The governor has grossly violated, among others, 1, Articles 10 and 73 of the Constitution, 2, Section 7 and 11, subsection 1C of the Meru Honors and Awards Act 2018 by naming a public road after her husband without following the applicable statutory procedures. Charge number 7, contempt of the Assembly. The particulars of this charge are as follows. The governor has grossly violated, among others, 1, Articles 10, 174, paragraph I, 185, clause 3, and 195 of the Constitution, Section 39 of the County Governments Act 2012, and 3, Sections 18, 22, and 27 of the County Assembly's Powers and Privileges Act 2017 by engagement, connivance, and or complicity in the following. A, refusal to honor lawful summons to appear before the Assembly's Sectoral Committee on Justice, Legal Affairs, and Cohesion to answer questions on the matters raised in the preceding parts of this impeachment motion. And B, directing her Chief of Staff and accomplice and lackey in malfeasance to write a contemptuous letter to the Assembly in response to lawful summons to appear before the Assembly's Sectoral Committee on Justice, Legal Affairs, and Cohesion. And C, in the refusal by her CECM, Finance, and County Secretary to furnish documents to the Assembly on the frivolous grounds that 1, an inchoate audit process was underway, and 2, the matters raised by the Assembly were sub judice, the latter frivolous ground being also disingenuous and contrived when viewed against the fact that the governor has already been convicted of contempt of court. The Honorable Kawira Mwangaza, how do you plead to the 7 charges? Guilty or not guilty?
Not guilty.
Thank you. You may proceed to take your seat, Honorable Governor. Next is the opening statement on behalf of the County Assembly. Council, you have exactly 30 minutes. Anything said after 30 minutes will be off record and may not be useful to your client.
Order number 3, hearing and determination of the proposed removal from office by impeachment of Honorable Kawira Mwangaza, the Governor of Meru County.
Thank you very much, Mr. Speaker and Honorable Senators. I'll be sharing the 30 minutes with my learned friend, Mr. Marius Maranya. In summary, Mr. Speaker and Honorable Senators, the impeachment motion before you is the third one in barely a year presented before the Assembly against the Honorable Governor Kawira Mwangaza. The first impeachment motion was presented before the Assembly on 22nd of November 2022. It did not reach the Senate because the High Court issued an order preventing the MCAs from debating it. The second one was filed on the 5th of December, and it was brought before this Assembly. It contained, Mr. Speaker, 62 charges of nepotism, illegal appointments, usurpation of the constitutional and statutory functions of county organs. It contained allegations on incitement, bullying, and vilification of other leaders, a matter now still before you. It revolved around disrespect to the Assembly through forceful entry and mobilization of riots against the Assembly, a matter now before you in different particulars. It involved violation of public finance management laws. Again, a matter before you, only the facts have changed, the fundamental problem remaining. And then, of course, that motion came here and it did not succeed. Notably, Mr. Speaker, when we came, the governor took the posture of an innocent and vulnerable victim of toxic masculinity, harmful patriarchy, gender stereotyping, gender discrimination, and political machinations. And in short, the governor took the posture that if something went wrong in Meru, as we submit, something has been terribly wrong in Meru for a year now and counting, our defense was, it wasn't me. It reminded us of Shaggy's song, Mr. Speaker, in which a young man is caught engaging in some hanky-panky, and even though he recorded on camera, he is caught in with all the evidence, a singular response through and through, it wasn't me. After we moved from this Senate, Mr. Speaker and Honorable Senators, even though the Senate dismissed the charges, it gave the governor many pieces of free advice, free lessons on how to run the county. And after we left here, there was a brief honeymoon of peace in Meru, lasting only a few weeks. This honeymoon was characterized by courtesy calls by various leaders pledging in public to support the governor and promises by the governor that she would turn over a new leaf and Meru would be lastly peaceful and orderly and run in accordance with the Constitution. When we came here, Mr. Speaker, I recall prefacing our presentation about, or rather with the story of a leader in Europe who that time we were telling you had waged wars on all 4 directions of the campus, north, south, east, and west. On each direction, this leader was at war with another country and another civilization for no good reason. Today, Mr. Speaker, we want to preface the motion before you with yet another allegory from Europe about the tragedy of a man from Russia called Kodraty Rayelev. This was a multi-talented Russian citizen who was a poet, publisher, oralist, military officer. He was the embodiment of all the nice things a single man can achieve in a single lifetime. He was implicated in a treasonable act called the Decembrist Uprising of 1825 in Russia, which sought to depose the Russian monarch. Those days, the monarchs were called Tsars, from office. And after he was convicted of this offense, he was sentenced to public execution by quartering. This is a method of execution, Mr. Speaker, that involved tying the four limbs to a horse, and the horse is being driven in different directions, or cutting the body in four pieces and exposing the bowels and whatnot. Pleas were made to Sir Nicholas, who was the monarch, that this was too macabre a method of execution, and even though the sentence could not be vacated, the king was implored to impose a more humane way of execution, and the king agreed that Kodraty Rayelev could be executed by hanging, which I think is the method in our laws for executing people. On the day of execution, and in those days, Mr. Speaker, executions were done in public stadiums like Nyayo Stadium, full of people and spectators. So on the day of execution, this gentleman is led to the gallows, the crowds watching in the full stadium, and as he fell, you know, you're supposed to fall so that your neck breaks and you die, the rope broke and Kodraty Rayelev fell to the ground, and after a few seconds of dizziness, he dusted himself and addressed the gathering, telling the crowd, you see, in Russia, they don't know how to do anything properly. They don't even know how to make a rope. We are submitting, Mr. Speaker and honorable senators, that by the governor persisting in the very series of misconduct that brought us here 1 year ago, the only change being the particulars, she's actually telling you that you see in Kenya, the Senate doesn't know how to do anything properly, not even how to impeach a rogue governor. Anyway, after this guy fell to the ground, in Russia then this was considered a message from the gods, that the gods did not intend the prisoner to be executed, and the king was allowed to grant a pardon if this type of miracle happened. So, a messenger was sent on horseback to the monarch in a large white horse to tell him about this miracle and request the monarch, as was the custom in Russia, to sign the pardon. And indeed, the monarch began drafting the pardon, and just as he was about to sign it, he asked the messenger, by the way, did Rayelev say anything when this miracle of breaking of the rope in a public hanging occurred? And of course, the messenger told the king, yes, he said in Russia, they don't know how to do anything, not even how to make a rope. And the monarch said, in that case, let us prove the contrary. The monarch tore the pardon and directed that the execution be repeated the following day, and this time the rope did not break, marking the end of the sad story of Kodraty Rayelev, a Russian poet, singer, military officer, and many other things. Why do we say this story, Mr. Speaker? We'll be presenting evidence before you, and even as the charges were read, you heard several times the clerk saying this issue was alive in the previous proceedings. What happened? The governor, after the brief few weeks of camaraderie, adopted a defiant stance in which she held, and she has it even in her own evidence, several public rallies defiantly telling whoever can to listen, kaende, kaende, kabati, kabati. Kaende, kaende, Mr. Speaker, is Sheng. It's Nairobi slang for I don't care, Whatever will be, I'll do what I do. In Swahili, they say, na liwe liwalo. That is the meaning of kaende kaende. And we'll be showing you how, throughout the last 1 year, even after the graceful lessons from Senator Tobiko, I recall, from the other senators, the governor's mantra in persisting on this, a series of misconduct is, I don't care, whatever will be, will be. Kyocera, Kyocera, whatever will be. She doesn't care about the consequences, the future, and whatnot. That is how, Mr. Speaker, we have come before you with a motion arranged under 7 thematic counts, setting out 39 specific forms of gross violations of the law and the Constitution, and which, in our humble submission, are conduct and becoming of any leader. Mr. Speaker, we expect, and it will happen, although I'm not a prophet, just like last time, the governor will appear on this podium taking the posture of an innocent and vulnerable victim of toxic masculinity, harmful patriarchy, gender stereotyping, political schemes. That's what our response tells you. It is back to, it wasn't me, by Shaggy. And the governor, if you want to confirm it, at page 2 of our response, she tells you, this motion will not be here. It is a scheme by our deputy who is power hungry to take the governorship through the back door. She tells you it is the Njurin Cheke. She tells you if our own officials, our own secretary, our own chief of staff has done anything wrong, even the things she acknowledged, she said they bear their own responsibility. It wasn't me. In short, she will come to you looking as meek as a lamb. But luckily we have lived through the experience, Mr. Speaker. Our message to the Senate is if you acquit her this time, she will walk out this door and it will be kaende kaende, Kyocera, Kyocera. Whatever will be, I don't care, na liwe liwalo, and Meru will be back to the perpetual, endless crisis that it has been engulfed for a year. We will be showing you that the governor has made several admissions before the county assembly. What we find strange is that now in our response to you, she produces documents she failed to produce before the assembly. We will be able to show you beyond any shadow of doubt that those documents are forgeries. And in conclusion, so that my learned colleague will take the remaining bit, just like last time, Chair, we are telling you not to fall for the rules. If you see a humble, meek, polite-looking governor, it is because the occasion of the day requires that to look meek, humble, vulnerable, and whatnot. But if you make the mistake this time round, it will be Kyocera, Sera, whatever will be. I don't care. Kaende, kaende. That is what she will do. And for those reasons, for purposes of my part, Chair, we are asking you to borrow from Nicholas I of Russia in 1825, 1826, to prove that the Senate of the Republic of Kenya can actually do things properly by impeaching a rogue governor. I led the floor to my learned colleague, Mr. Mari Maranya.
Thank you, Honorable Speaker, Honorable members of the Senate. My name is Marius Maranya. And Honorable Speaker, for the interest of time, allow me to jump right into it. I will start by setting out the mandate of the Senate, as has been clearly set out previously by Apex Court, the Court of Appeal in the case of Wambora's case, as well as the Supreme Court in the Sonko's case, did set the mandate of this House as clear as their role is to investigate and confirm that there exists sufficient evidence to substantiate the allegation made against the governor. Therefore, the Supreme Court noted that the Senate does not sit as an appellate forum. Theirs is a single role, that is to investigate and confirm that the allegation, as well as the evidence that have been adduced by the Senate, is substantiated. They have gone ahead, Honorable Speaker, to state that impeachment proceedings are not in the nature of criminal proceedings. They are not proceedings to establish culpability or criminal culpability against the governor. However, they have stated, the court has stated, that the impeachment proceedings is all about accountability. It's all about political responsibility. It's all about political governance. And as a result of that, they have set the standard of proof. Unlike in criminal cases where the standard of proof is beyond reasonable doubt, the proceedings of impeachment, it is not required to prove beyond reasonable doubt. Indeed, the Senate went ahead and stated that the proof is way below the standard of, way below that of a balance, beyond reasonable doubt, but slightly above that of a balance of probability. In the fullness of time, Honorable Speaker, Honorable Members, we shall produce evidence upon your leave to call evidence that to prove that the governor has failed or breached the political responsibility. She is in breach of political accountability, she is in breach of accountability, and she is in breach of political governance in a manner that warrants her impeachment. We shall again demonstrate to this Honorable House that the conduct of the governor over time, over the 1 year she has been in office, has not been beyond reproach as is required. The conduct of a state officer should be beyond reproach. Indeed, it's likened to that of a sister's wife. But instead, or to the contrary, the governor has behaved in a manner that has been construed by this House as well as the court to amount to an impeachable conduct. We shall demonstrate that one upon the opportune time, Honorable Speaker, when we shall be required to call evidence and adduce, to call witnesses as well as adduce evidence. We shall demonstrate, Honorable Speaker, that the governor, once a pedigree person, has disastrously turned tragic and has been likened in Meru County to King Saul. We shall demonstrate that the relationship between the governor and the people of Meru, the relationship with the governor and the leaders of Meru, both elected and political and non-political, our relationship with women organizations in Meru, our relationship with all actors, including the informal government called Judjeke and all other leaders, including her deputy, has irretrievably broken down. And that therefore, there exist irreconcilable differences between the governor and everybody, all actors within Meru. We shall demonstrate that one clearly, Honorable Speaker, when we will have a chance to adduce evidence. We shall also demonstrate to you in the fullness of time how the governor has placed the county resources that is appropriated by this Honorable House to Meru County has been placed under the custody or under the domain of our relatives, and that's a relative with very close blood consanguinity, that is sister, brother, for one reason, Honorable Speaker, to plunder it. To plunder it. We shall demonstrate how Meru County having a very high prevalence of cancer, and it is even said that we top in the entire world, not even in the country, which has been prevalent for quite a long time. Meru has been leading in cancer. And when the county got an opportunity from an international well-wisher that please send us a group of technical persons, technical in terms of cancer treatment, to come and benchmark with us for purpose, to come and inspect the cancer treatment machines for purposes of equipping Meru Cancer Treatment Center, the governor was audacious enough to get clearance from the Minister of Devolution, and you'll be surprised that instead of getting for the oncologist, the radiologist within Meru, serving the cancer center in Meru, was audacious enough to put into the flight her sister, her brother, and her brother-in-law to go and for 2 weeks in China to go and be frolic of themselves. This is an opportunity that we lost as a county. It's an opportunity that we lost to equip the only cancer center that we have in Meru. We shall demonstrate that one at the opportune time. And the letter that was sent to that is not even shocking enough, the letter that was sent to the Ministry of Devolution as well as to the Chinese embassy is that the following persons, a clear case of misrepresentation, are technical person matters of cancer. Yet, most of them, their education qualification cannot be accounted for. And the most educated in that team of sisters and brothers was one holding a diploma. Diploma in pharmaceutical technology. That is an assistant to a pharmacist. Even a pharmacist is not qualified in that one. And remember, this is done while living out qualified oncologists, qualified radiologists, and all manner of experts in relation to cancer treatment. We shall demonstrate to you at the opportune time how the governor has employed 8 extra chief officers without an approval of the county assembly at all. It's like the president appointing a minister and do not subject him to the National Assembly for approval. These chief officers, most of them are completely unqualified. They don't even have the minimum requirements, the minimum academic requirements. We shall demonstrate when you'll be asked to call, allowed to call evidence. Our governor has used our Kolea program to pseudo government money. We shall demonstrate at the opportune time how government vehicles have been staged to pursue the Okolea programs, which is a program not meant to help people, but to vilify leaders and other persons who are assumed not to be, to be raising any issue. We shall demonstrate at the opportune time how the governor has used her sister and her brother to swindle the government money to the tune of, just a cursory look at it, 78 million shillings going to an individual in the name of prepayments. Prepayments. Where a sister would owe 8 interest in 1 day. In 1 day, 8 interest in 1 day. We shall demonstrate that one when we'll be required to call evidence. We shall also urge you, Honorable Speaker, that the governor in front of you is not the first-time offender. He's not a first offender, and indeed she's a repeat offender who does not require or does not deserve the favors of this court. Honorable Speaker, I will also reiterate the role of Senate as far as devolution is concerned. Honorable Senate, you spent a whole lot of time to pass budgets for the interest of county, for the interest of devolution, only for it to be placed under at the disposal of sisters or relative for purposes of bladder. This, you have a sword. You are the custodian of devolution. You have the sword, and you can't sit lying down for long. You have you spare the rod, and the child will be spoiled. We shall be asking you to please crack the whip against the governor for the interest of Meru. We will be faced with 2 competing interests. 1, devolution to work in Meru for the interest of Meru, and number 2, to help the governor save her private job. Good thing is that will be public interest. You'll be confronted with the public interest against a private interest. Kindly save the governor, save the Meru at the expense of saving the governor. My apologies, yeah. my apologies. Certainly, save the Meru, save the entire people of Meru, and not the Honorable Speaker, at the opportune time, we shall demonstrate that the center cannot hold anymore. And we'll be urging you to save the members of the County Assembly that back and forth, to and from the Senate, to and from the Assembly. If someone has been brought here barely 10 months ago, there must be an issue. It is not just in vain, it is a resort where the center is not able to hold anymore. We shall demonstrate how the governor has completely violated a court order, completely. With a lot of, just like she contempted against this Senate by completely making a mockery of their advisory by Honorable. For Aulia, sorry, I'm reminded it's for Aulia. The way the governor has completely usurped the county public service board. We'll give you an example where the governor advertised for 3 officers in her office, that is her personal public communication officer 1 and 2, and the governor shortlisted 17 for purposes of recruiting 3, and out of 17, the governor only recruited 1. Out of 17 who applied, instead of recruiting 3, the governor recruited 6. And what surprises me, and should also surprise the Senate, is that out of the 3 that were recruited, only 1 was in the shortlist. Only 1 in the shortlist. The other 5 were not in the shortlist, and they were not even applicants. We shall demonstrate this one. Honorable Speaker, I have had a cursory look at our defense, which she has only attempted to, in the misappropriation of funds, the governor has only attempted to prove by submitting interest in relation to only, instead of accounting for 78 million, she has only accounted for 2.3 million. And if you look at the 2.3 million, the documents that have been used, that is the work ticket as well as the voucher, 99% of them are not signed by the examiner, are not signed by the director of accounts, and therefore they have been prepared hurriedly for purposes of your consumption. We shall demonstrate to you how a certain work ticket, how one work ticket has been used to account for 17 interests. It has been used 17 times with the same registration number, the same serial number, has been used 17 times. And when we called upon to call evidence, we shall demonstrate that one clearly. We shall demonstrate to you also how even the work tickets that have been used do not follow that natural chronology. Do not follow natural chronology to the extent that it is indicated that the governor on the 7th of October went to Nairobi. The next which follows is 10th of October. And the next that follows, you find it is 4th of April, a year after. You started wondering whether the governor was able to return, the whole access back to some months ago. That is clearly demonstration of forgery. You look at our document, you'll be surprised that she has zero defense. What she has is just a mere counterclaim. You are asked, why did you steal this government money? Oh, you say during cheke. Why did you say this one? Oh, Honorable Poro Abodi. You ask, why did you usurp the powers of the county assembly? Oh, the deputy speaker. You ask this one, oh, that. Instead of clearly saying, I have not done this, and this is the evidence to that effect. We shall demonstrate. I remember I was taught by the Honorable Senator Professor Tom Ojenda, who told us, at least if you decide to answer a wrong question other than the one that was asked, please try and answer it correctly. And instead, the governor did not address the defense, the claims, and in her defense, she produced her own counterclaim in form of, I don't know, it's a motion to impeach who, and answered it wrongly. It's a double jeopardy. You get the question wrong, and you answer it wrongly. So, Honorable Speaker, with that, because of the interest of time, we shall be, at the opportune time, be called upon to produce all the evidence, or to produce all the evidence in respect to the matters that we have raised. I thank you, Honorable Speaker.
Thank you. Next is opening statement on behalf of the Governor. Council, you have 30 minutes. At the end of the 30 minutes, the microphone will go off. Anything you say after that will be off record and of no use to your client.
Thank you so much, Mr. Speaker, sir, and distinguished senators. My name is Elisha Ongoya, for the record. It gives me great pleasure, Mr. Speaker, sir, members of the Senate, to address you representing the Honorable Kawira Mwangaza, the Governor, Meru County. we find it necessary to open our remarks by reflecting on the wisdom that informed the framers of our Constitution in prescribing a two-tier process of removal of a governor from office. This case has taught us that the framers of this process were indeed wise. Why do I say this? This House occupies a higher quasi-judicial pedestal in these proceedings for three reasons. Number one, in this House, the accuser, the prosecutor, and the judge is not one and the same person. Unlike the process below, where the motion is moved and supported by the same persons who will prosecute it and the same person who will make a determination by the vote. That was wise on the part of the framers of our Constitution and the law. Number two, the diversity of this House in terms of the origin of the decision makers implies also that the members of this House do not come, for lack of a better word, contaminated by local politics. And number three, this House, in terms of the architecture and design of the Constitution and the decision-making process in this matter, is expected to bring the much desired objectivity in this process. The Honorable Kawira Mwangaza also takes this opportunity to reflect on the constitutionally prescribed grounds for removal of a governor from office. Mr. Speaker, sir, we appreciate that this was one of the first orders you took members through, because it is critical that throughout this process, we keep this criteria at the back of our mind. The drafters of our Constitution grafted grounds using specific adjectives. Number one, gross violation of the Constitution. I've been asking myself, why not just violation of the Constitution? Number two, where there are serious reasons for believing that the county governor has committed a crime under national or international law. Again, I was reflecting on the question, why not just reasons to believe? Why serious reasons to believe? Number three, abuse of office and gross misconduct. Again, I was asking myself this question, Mr. Speaker, sir, distinguished senators, why not just misconduct? It's our humble submission that it cannot be for nothing that the framers of our Constitution and the law used these descriptive words. Whereas the Constitution and the statute do not give us a definition of gross misconduct, the Supreme Court of this country, an important institution in giving meaning to our Constitution, has supplied us with meaning of that term in a process that involved the removal of a judge from office. This was in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Muya. And in the interest of time, I will just pick out the attributes that the Supreme Court said constitute gross misconduct. The Supreme Court used the following words: it must be atrocious, it must be colossal, it must be deplorable, it must be disgusting, it must be dreadful, it must be enormous, it must be gigantic, it must be grave, it must be heinous, it must be outrageous, it must be odious, and finally, it must be shocking. Those are not my words. Those are the words of the Apex Court of the Republic of Kenya, giving all of us guidance on how to deal with matters such as this. I also observe that the rigorous standard that must be applied to the removal of a governor in office, let me withdraw that. Let me say, number one, the standard for removal of a governor in office, taking into account the adjectives used by the drafters of our Constitution, as defined or as interpreted by our Supreme Court, suggests that the process must be rigorous. And I was trying to rationalize it. Why did the lawmaker insist on such a rigorous standard? It must be consistent with the rigors of assuming the office itself, because the process of assuming the office of governor is not mild. Mr. Speaker, sir, distinguished senators, I am aware that there are members sitting in this House who have attempted to vie for office of governor, and they'll bear with me witness that that process is rigorous. In the case of Meru, it must be borne in mind that there are 772,000 registered voters whose voices were heard, and out of those voices, Honorable Kawira Mwangaza assumed the office of governor of Meru County. That is a rigorous process. Mr. Speaker, sir, distinguished senators, the Honorable Kawira Mwangaza beseeches this House to employ the above test as what we describe as the constant north, the guiding star in these proceedings. What the governor is telling this House in simple terms is this: do not be preoccupied by the allegories from Europe. Look at the evidence before you. The law of evidence, which my learned colleague, Dr. Mudomi Thiankolu, has taught for many years at the university, presents as follows, honorable senators. Evidence is not counted. Evidence is weighed. Eventually, put this evidence on the weighing scale and come to a consensuous conclusion that can we, in good conscience, remove a fellow citizen from the high office of governor on the strength of the material presented before us. Mr. Speaker, sir, distinguished senators, one may ask, and this evidence that the governor has presented here, where was it before the assembly that undertook the first impeachment process? The Hansard of the assembly will bear the governor out. That the governor's legal team went before the assembly with this evidence and asked the Speaker of the assembly, direct us on how we present this evidence before you. And the Speaker of the assembly ruled that both the legal team and the governor herself were, in parliamentary parlance, strangers and could not table material before that assembly. Mr. Speaker, sir, distinguished senators, 2,400 years ago, that great Greek philosopher, Socrates, is documented to have prescribed the 4 essential attributes of anyone who sits in the position of a judge, as you do today and as you will do tomorrow. He observed, and I quote, 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. Distinguished senators, today and tomorrow, in relation to the business that keeps us here before you, you sit as judges. The humble plea of the governor, Meru County, to this distinguished House is that you apply this 4-part Socratic test And that if you do that, she asks for no more favor. The chips will fall in their place and she will naturally be vindicated. The governor has furnished evidentiary material before you in the nature of, number one, her response, affidavits in support of that response, an index of annexures, which are documentary exhibits, and 2 flash discs with various video clips that will contextualize for you what the political atmosphere in Meru is. Despite that political atmosphere, which is the reality in which this governor operates, the Controller of Budget report has indicated that this governor leads a county that has a 71% absorption of its development budget. Honorable Senators, you sit here oversighting many counties, and you know better than I do the degree of efficiency one requires in this country to even achieve that feat. The latest InfoTrack research, which is less than a week old, has ranked the Honorable Governor Kawira Mwangaza among the top 4 performing governors in this country. And that is the person that is presented before you and who has been treated to the descriptive epithets that the Learned Counsel for the Assembly have described just a few minutes ago. We had the privilege, Honorable Senators, of following debate on the motion on whether this House will go the committee way or will go the plenary way. And we were persuaded by the following submission by members of this Senate. We want to know what is happening in Meru. Evidence will show you, Senators, what is happening in Meru. When you look at the evidence presented before you by the County Assembly, and I emphasize that because the burden of proving these charges is the burden of the County Assembly. Because at the end of it all, this Senate has to make a finding whether the charges, my apologies, have been established or have been proved. That evidence by the Assembly will fall into 9 broad categories. You realize, Honorable Senators, that all the evidentiary material before you presented by the Assembly is information that was generated between August and September 2023, solely for that period, for purposes of these impeachment proceedings and nothing more. So you'll be told there is a complaint by a public-spirited citizen before the EACC. And that complaint before the EACC is the basis of these impeachment proceedings. You'll notice all that material is generated between August and September of 2023. You'll be told there is a summons before the County Assembly that was disobeyed. When you look at the record, you'll discover that summons was issued in this period. So you'll see a period where there is a spirited, deliberate design to generate material to start an impeachment process. The second category of evidence, or claims, my apologies, the second category of claims, and some of these may be overlapping, is you'll come across claims before you whose evidence is claims elsewhere. We are claiming before you that the governor is misusing county resources, not because the Auditor General's report says that, not because we have evidence from IFMI saying that, no, because there is another complaint before EACC saying that. So use a complaint as the supporting material for the complaint before you. The third category is that all the claims made before you, we shall be asking this Senate to seek clarification by way of asking, and we shall be asking this Senate to bear in mind as it makes a decision, which of those claims shows what action or inaction on the part of the governor. The county government is an entire system of government. A lot of things may happen. A county government driver may be driving and may knock down somebody on the vehicle. That's a wrong. The question we'll be asking is, how do you tie that to the governor? So of all these claims, we shall be demonstrating to you that there's a failure to show the causal link between the case presented before you and the person presented before you for removal from office. The fourth category of matters will be what you call, my learned colleague gave me these words, dead matters that have been resurrected for purposes of infusing an element of meaning to this motion. You'll discover that the claims and the supporting material before you will be the same claims and supporting material that were presented before this Senate a while back, as again the same governor, and this Senate voted to find that those claims on that material, that very material now coming before you, did not pass the threshold for removal of a governor from office. You will then come across matters that are pending before other constitutional bodies. Complaints pending before the courts, complaints pending before EACC, over which no determination has been made that's adverse against the governor. Then the fifth category, my apologies, the sixth category, is you will come across very contradictory claims. Very contradictory claims. Allow me to just demonstrate this by way of example in two cases. When you look at count 5 of the grounds in support of the impeachment motion, you'll see a claim of contempt of court. You'll see that claim. When you look at ground 1, in particular, sorry, count 1, my apologies, count 1, ground C, you would say a claim that the governor paid full salary and benefits to Dr. Ntoiti, Paul Mwaki, Kenneth Kimathi Mbae, and Joseph Kature Mbae. So you're accused of contempt of court in one count. You're accused of paying salary and benefits in another count. First, the Senate will reflect on the question whether the function of employment of these employees and their remuneration is a function of the governor within the county government structure. But for now, let me just inform you that the act of paying these 5 people is actually in compliance with that very order. So you comply with the relevant county government official delays to comply with the order to pay, he's accused of contempt of court. He complies by paying, he's accused of making the same payment to the same people. Good people in good conscience, that is the case in respect of which the governor has been most dramatically described by the assembly side representation. The next category of claims will be claims focusing on the person of the deputy governor. Focusing on the person of the deputy governor. I will address some of these claims briefly in the interest of time in my next limb. The next category of claims are just plainly false claims. One of the hardest part of my preparation for this case is how you prepare to respond to a lie, apart from saying, but it is a lie. It is not true. For example, You'll get a claim that somebody by the name Kature Rukaria, James Karimi, Lady Ankatha are relatives of the governor. They simply are not her relatives. I mean, how much more do you say to that? You'll be told that the governor has employed Rose Guantai and Kenneth Guantai in the county government. These are employees of the National Police Service. They are police officers employed by a completely different constitutional body. Honorable Senators, you know better than I do that as protected state officials, the level of latitude one is given to consult with the authorities in the police service for purposes of allocating your security. You don't become an employer of that person. You'll be told that the governor has embezzled county funds through one Miriam Guantai. That's what you'll be told. The evidence in support of that will be some attachments in pages 17 all the way to page 29 of the exhibits in support of the impeachment motion from that side. You will then go there looking for the name of Miriam Guantai as a recipient of the money. You will not get it there. It's just false. You'll be told that Nefat Kinyua is a brother-in-law to the governor. I have had to reflect on the meaning of the word brother-in-law. We have presented before you a marriage certificate of Nefat Kinyua because the name brother-in-law is a relationship that arises out of a marital relationship. To show you who he is married to in a monogamous union. That person is neither a relative of the governor nor the governor's husband. So I don't know how one generates a brother-in-law relationship outside that context. You'll be told that the governor has employed Edwin Mutuma Murangiri, a nephew of the first gentleman. Evidence will show that Edwin Mutuma Murangiri was employed by this county in 2017. This governor became governor in 2022. So even if she intended to employ him, did she re-employ him a second time? Those are questions that this Senate will have to deal with, just factually incorrect statements. Edwin Mutuma Murangiri is not related to the first gentleman as a matter of fact. So it is false. You'll be told that he is one of the people through whom the governor is swindling county funds. We will then take you to the IFMIS extract that they have presented and ask, show us the name of Edwin Mutuma Murangiri receiving any sum of money for any purpose in that IFMIS extract. You will not get it there. It's just false. Then there are some falsehoods that are also very courageous, senators, because they also lie about this Senate. You'll be told that this Senate, so to speak, stopped the governor in the last impeachment exercise from running the private charity project dubbed Okolea. You'll be told that. On that one, we think this Senate will be our witness, that you didn't do that. You'll be told, for example, 2 county vehicles, KAX 574V and KCB 845F, were damaged. First, they are described as county vehicles, damaged in one of the Okolea charity events. We have presented before this court official searches from the National Transport and Safety Authority, which can be the only source of information on who owns this vehicle. These are private vehicles not owned by the county at all. Just falsehoods. And you're told, honorable senators, that the governor has assigned diplomatic duties to her unqualified sisters. I was reviewing the law on this. Function number 1 in the 4th schedule of the national government, function number 1 is foreign relations. So how does the governor engage in foreign relations? Just falsehoods. You'll be told the governor has named a public road after the husband. I was reflecting on this, Mr. Speaker, sir, honorable senators. If you were to tell the assembly side to take you to Meru and take you to a road named after the first gentleman, you'll get the meaning of what is called a wild goose chase. You'll not get to any particular road located anywhere called the name of the first gentleman. Instead, they will tell you, let us remain on Facebook. There's some post on Facebook somewhere. Then you'll come across just distorted claims. Distorted, misrepresented claims. For example, Mr. Speaker, sir, and honorable senators, you run offices here and know that your offices here are supplied with hospitality supplies. Some sugar for your guests, some soft drinks, some water. So somebody will go to IFMIS and find an entry, hospitality supplies, which are things ordinarily bought from petty cash impressed. They will make a report and say, these are hospital supplies in their report to you, to create an impression that this person in the governor's office is actually supplying our hospitals. And I mean, how do you deal with that, honorable senators? These are the things that have been brought here. When you hear my learned colleagues on the other side making very dramatic representations, let me manage your expectations. There is something called an anticlimax. You'll be told that the governor is culpable of bullying, undermining, and posting insulting and demeaning messages about the deputy governor. This is a sad claim, and I must emphasize this. I would want you to finally contextualize this matter. There is a video clip that will be played here of the deputy governor chanting with a group of youths in Meru County, chanting the following slogans. Kawira doesn't have a home. Oh yay, oh yay. She doesn't have a home. Oh yay, oh yay. She's a prostitute. Eh yay. She's a prostitute. Eh yay. Mutuma, kindly strategize. Eh yay. You will see that is the video that the governor replies to. And the governor says in reply to that video that is calling her a prostitute, that I cannot be intimidated and I cannot be cowed by these childish, mannerless, mobilized people. You'll be told, no, focus on these words, that I'll not be cowed by these childish, mannerless, mobilized people, but forget the video she is responding to in the same WhatsApp group, calling her prostitute. Honorable senators, the voting that you make in this Senate is a constitutionally prescribed voting governed by your conscience and your oath of office. The bundles presented by the assembly side are certainly bigger in volume than the bundles the governor presented here, because as I told you, how do you respond to a lie other than saying all these 100 pages are a lie? Then you keep quiet. They've given you a big house, big in stature, but if you look carefully at the pillars of that house, if you look carefully at the columns of that house, you'll discover that their constituent material are biscuits. We urge you to accordingly vote, putting that house of biscuits on the weighing scale and see whether it will collapse the scale as a dominant consideration in your voting in this matter. And that is the governor's opening statement. Thank you, Mr. Speaker, for the audience.
Let me take this opportunity to thank the parties for keeping to the time schedule. I believe going forward, if we keep it to the way we have expeded here now, we should be able to cover ground. Now, we are moving to adjourn the House, but a matter of housekeeping. Lunch will be served to the parties, both the county assembly and the governor side. You will be served with lunch. You'll be guided accordingly as to where you'll have this lunch. We will, of course, later on resume. Therefore, don't take lunch and disappear, because we will need you here at 2:30. Now, honorable senators, kindly be upstanding. Now, honorable senators, it is now 4 minutes to 1 p.m. Senator Karen, do you have any medical condition? Honorable senators, it is now 1 p.m. Time to adjourn the Senate. The Senate, therefore, stands adjourned until today, Tuesday, 7th of November, 2023, at 2:30 p.m. Thank you.